Sexual intercourse with a child between 14 and 16 years of age is an offence under Section 66, subsection 3 of the New South Wales Crimes Act. The maximum penalty if the case is decided in the District Court is 10 years imprisonment. The maximum penalty if it's decided in the local court is 2 years imprisonment. Now, for a person to be found guilty, the prosecution must prove 3 things beyond reasonable doubt. The first is that you had sexual intercourse with a person. The definition of sexual intercourse is contained in another video that we have on this website. The second thing is the person was aged over 14 years and below 16 years. The third thing is that there was no consent. Now, to be guilty, the prosecution must prove what's called a knowledge of consent. That means they must prove beyond reasonable doubt either that 1, you knew the other person was under the age of consent, i.e. under 16 years of age, or 2, you were reckless as to whether the other person was under 16, or 3, you had no reasonable grounds for believing that the other person was under 16. Now, in determining consent, the court will have a look at a whole range of surrounding circumstances. For example, your previous dealings with the complainant, the context in which the incident occurred, any specific inquiries that you made about that person's age, and of course the results of those inquiries. If you are guilty of the offence, the sentencing statistics for the District Court suggest that 63% of people were sent to prison. The average prison sentence was 3 years full term, and that's the entire sentence, and a 12-month what's called non-parole period. Now, the non-parole period is the time that someone must spend in jail before being eligible to apply to get out of jail. 16% of people in the District Court were given a suspended sentence, and that's a good behaviour bond, which if breached will likely lead to the imposition of a full-time prison sentence. The sentencing statistics for the local court suggested that 35% of people were given what's called a Section 9 good behaviour bond, and that's a good behaviour bond with a conviction. 30% of people were sent to prison, 26% were given a suspended sentence, and 7% of people were given what's called a Section 10. That means you're guilty, but no conviction is recorded against your name. If you're charged with the offence, it's important for your lawyer to try to keep the case in the local court where the penalties are less severe. If you're pleading not guilty, your lawyer should fight for the withdrawal of the case early. They can do this by showing that there is insufficient evidence of sexual intercourse, or there is insufficient evidence of knowledge of age. They can, for example, present evidence to the contrary of that, or by presenting a valid legal defence. If the prosecution refuses to withdraw the case, they should of course fight to prove your innocence in court. If you wish to plead guilty, they should of course push for the most lenient results. For example, a good behaviour bond, or even avoiding a conviction altogether.